construction of whatever it is you're building.
Right. If you look at our table on 4-6, the very first thing it says, its use may be permitted subject to the policies and regulations of this program. So if people see a P, they know, I need to really look at the policies and regulations to see what that.
Sure, but the details really exist in the text, and I think there was discussion of, well, actually, it's in the text just prior to, it's on page 4-5. Table 1, recommended language by staff is Table 1 is intended to illustrate the text of the master program. In the event that discrepancies exist, the text shall govern. So, again, the table is just meant to be sort of a quick glance reference, but really the meat's in the text.
So, John, did you see how there was 2 types exempt in the full-blown SDP, and then 3 layers of conditional use? The CACD. I don't know if we answered your question on this.
Conditional administrative discretionary or full-blown CUP.
Full-blown CUP.
So if I can just let you know, everyone thinks of the conditional use process as being harder than the substantial development permit, but actually the reverse is true in our proposal, or at least the staff proposal, in terms of process. The criteria are greater for the review. However, if it's a conditional administrative use, we're determining it, we're issuing a decision at the staff level rather than going to a hearing examiner. Right. So if a mooring buoy is a P, permitted use, which is a substantial development permit, that means you're looking at currently it'll require SEPA and water and a hearing examiner, so you're looking at $3,500 perhaps for a permit fee, whereas if it, and I'm just general numbers, however, if you're doing a substantial that was a substantial development permit, if it was a conditional administrative permit process, then we don't have the public hearing and the hearing examiner. However, we do have notice to the neighboring parcels within 300 feet. And the cost of that application with SEPA might be $2,200 or so.
And it's also noticed to anybody on that list that's asked to be notified, so
yes.
Tribes can be notified, the state can be notified, and then if people are unhappy with that decision, they can appeal.
In a Type 2, they could appeal to the hearing examiner.
In Type 1, what happens?
In a Type 1, the appeal goes to Superior Court and the Shoreline Hearings Board. In a Type 2, there's a step that's an administrative remedy that's possible prior to going to the Shoreline Hearings Board. So
the point is, it doesn't end with staff necessarily.
Yeah, if there's appeals, correct.
And so potentially.
And let me also say, the conditional use permit, it would be a final determination by Department of Ecology that our decision is accurate and the proposal is consistent with our locally adopted code. So
going to that more about what's ecology's role at the CUP. They do not conduct a new hearing. They do not enter new findings on new criteria. They re-examine our decision and conclude whether we applied the right findings and conclusions of law to our criteria. Same criteria that we use. They just double check.
Yeah. And if you go back to the whole beginning of this whole thing, it's partly looking at the state's interest in these state waters, and this whole thing has been determined by that point to do that. You know, with the local decisions do protect the state interest, and so they look at it and say, well, you apply the local code, and by definition that protects the state interest, so you did it according to Hoel, nobody made any
right.
big mistakes.
Well, let's ask Jeffrey about that. Okay, so we send out a CUP, we've approved it, you then evaluate it, and then you submit back to us
Yeah, what I do is, well, two things that are worth noting here. One is that before the local decision gets made, virtually all the time when there's any kind of controversy or concern, the DCD staff contact us in advance, and we typically, myself, would go out on a site inspection pre-application, and whatever concerns I would foresee at the state level would be considered at the local review level. And then the decision comes to me, I read the staff findings and conclusions and whatever hearings and examiner report against the WAC 173, 26, 27, 160 criteria, and yeah, affirm it, write a letter, file it, give it to my supervisor, and when our letter goes out, then it's official.
And if you disagree,
That was my question. You disagree with.
Right. If at the local
Procedure.
decision-making process, something that we think is important doesn't get addressed, we do have the option of adding conditions to the permit and approving it with those extra conditions that would make it consistent, or we have the option to deny it. But I can tell you that statistically, it's less than 1% of conditional use permits statewide that we deny. It's very rare. And it's also infrequent that we add conditions. So it's quite uncommon. Typically it all gets sorted out at the local level and we're just affirming it at the end.
Yeah. And then that could be appealed if the person
That's right.
didn't want to go along with that. So,
So primarily you're evaluating county procedure.
Yeah.
Yeah.
Yeah, it really is mostly a local decision, and it's using the criteria in the
That's what I wanted to hear.
right.
state code.
And less expensive probably for the applicant than doing the shoreline substantial development permit. So,
well, see, there's a county cost too. Okay, this is what we talk about with the hearing examiner. We don't like it when nobody shows up at the hearing examiner. Okay, just the examiner, the staff, and the applicant. Okay, those types of hearings we think should not be held because there's no real interest. Okay, but yeah, it's nice to have the hearing examiner who will give a legal decision. The county administrator budget pays for the hearing examiner. The applicant does not.
Right.
The applicant pays for the DCD fee and staff time. So our fee is based on the average hours it takes to process it to a staff report and to the hearing examiner. So the applicant's paying for DCD's review, and the general fund is paying for the hearing examiner.
right.
I'm thinking, I really appreciate the descriptions of conditional use administrative, conditional use discretionary, and conditional use permit. But, you know, for this to stand on its own, I was looking for these in the definitions section, and I didn't find them. So I would think that someone who's trying to understand these regulations should be able to go to the definitions table and find them.
They're fairly lengthy descriptions that are already in Article 9. We could maybe put a reference in Article 2.
How about that? How about putting a reference in Article 2? You know, see Article 9 just to save paper, but
Sure. Okay.
because, I mean, one thing nice about the definitions is people know where they are, they can go straight to them, they don't have to read through the whole document.
It's good to figure out where it is.
Yeah.
That really makes sense.